Hello, everyone. Many apologies for the delay. We were having some technical issues. Thank you for waiting. I'll wait a bit for everyone to join from the waiting room. So hi again for the fourth day of the Virtual Work Experience Program. My name is Silvana, and today we're joined by Eleanor Thompson. We're going to share a bit of her bio in a minute, but I'm very thankful for her for being here, as she is also one of our advisors. I'm joined by the Safi as the co-moderator of this session. Floor to you, Safi.
Now, I'll be saying a little bit about Eleanor. So, she is a public interest lawyer and social justice advocate. She is the founder of Citizens Barray, a platform for empowering citizens to drive social change in their communities and beyond in Sierra Leone. She is also in private legal practice with GPK Legal, one of Sierra Leone's top law firms. Previously, she worked alongside community-based paralegals to provide direct legal assistance to communities in Sierra Leone, protect their land rights and environment. Eleanor has worked extensively on human rights, the rule of law, and justice at national, regional, and global levels for almost 20 years. She influenced positive legal reform in Sierra Leone by co-drafting Sierra Leone's progressive, more equitable new land laws. Eleanor was passionate about supporting people to utilize their power in innovative solutions to protect their rights, hold their leaders accountable, and shape the laws that affect them. When not using the law to help people solve problems, she works with and for girls and young women, creating opportunities for them to be empowered and inspired to achieve their goals. She is an advisory board for Global Girls Human Rights Hub and served as the inaugural rights chair, rights hub and served. I just repeated that. She served as the chair of the board of She Can, We Can, a non-profit organization that seeks to cultivate young, innovative female leaders in Sierra Leone. Eleanor is passionate about creating opportunities and for promoting women and girls in sports. Eleanor also holds a bachelor's degree in government and African studies from Harvard University, a Juris Doctor from American University, Washington College of Law, and a master's in international human rights with a distinction from University of Oxford. She is licensed to practice law in Sierra Leone and 2 US jurisdictions, New York State and the District of Columbia. So thank you so much for coming today, and the floor is all yours.
Thank you very much, Safia, and thank you, Ilvana. It is a pleasure to be with you all today. I'm going to apologize in advance if you see me looking up. It's because my screen is above me, but I'm going to try to look straight ahead so that it's not a distraction. If it does become a distraction, just sort of give me a signal and I'll put my head back down. Also, I know that you all have attended a number of these virtual work program sessions, and you may hear some things that are similar to things you've heard, from others in past sessions. So I'd love for this to be an interactive session. I will be asking certain questions. I don't know, Ivana, is there the possibility for people to respond by voice? Okay, great. So I'm going to make this as interactive as possible. That's my style. And we will take a short break at a strategic point. So everyone can stretch, have a water break, have a health break for a few minutes, and then we'll get back into it. So let me go ahead and start sharing. Are you able to see my?
Yeah.
Okay. It still hasn't come up for me yet. Okay, all right, there we go. All right. So I'm going to be talking, and we're going to be talking today about strategic litigation for girls' human rights. And why we're talking about strategic litigation. Oh, something got cut off there. Why we're talking about strategic litigation is because there are many tools that we have in our arsenal, in our like advocacy arsenal. And we're going to come to look at some of those tools in a second. But strategic litigation is something that has been used for decades, and you'll see some case studies as well as get a chance to talk through practically how you can use strategic litigation for advancing girls' human rights. The first step, the first thing I'd love for us to do, all right, is talk about frameworks, legal frameworks. This is a human rights program, and we always try to start with the law or start with policies, things that help guide us, things that whether it's governments, whether it's internally, domestically, or internationally, states have really put in place and asserted that these are our standards, these are the benchmarks, and these are the rules and the laws that we agree to adhere to when it comes to human rights, and in this case, girls' human rights. But before we talk about the frameworks, I want to ask you guys if you can identify some pressing human rights issues that are affecting either you personally, your community, someone you know, that are real issues right now. You can feel free to, I don't know if they can put it in the chat or if there's a way to raise hands. Ilvana, I'm not sure that I can see if people are raising hands. Okay, I don't think I can see. So if you want, you can put it in the, okay, there we go. Put it in the Q&A box. Wonderful. Perfect. So Tilly has given us an issue about access to well-informed reproductive medical care for girls. Maria San Miguel Vidal has highlighted access to education, FGM, which is an abbreviation for female genital mutilation, child marriage. Haley is bringing our attention to the rollback of women's rights and bodily autonomy, and particularly in medical contexts, domestic abuse and violence. Great. Reproductive health care, so access to menstrual products, equal access to education, and sexual abuse and other forms of physical and emotional and mental violence against women. Thank you. So why I wanted us to outline those before we get started on talking about the legal frameworks is because the frameworks are developed or have been developed to address very real issues, specific issues that affect girls' rights. And so starting with at a global level, we of course have the basic covenants on civil and political rights, as well as economic, social, and cultural rights that outline basic rights that apply to all persons. And because of that, they also apply to children and girls specifically. So the right to associate, the right to be free from torture, or cruel, inhuman, or degrading treatment, the right to pursue your development, the right to practice your culture, the right to family life. So there are a number of basic rights that apply to anyone of all ages, and so obviously they apply to children as well. And then of course there are specific international treaties that deal with the rights of children. Obviously girls fall within that, so that includes the UN Convention on the Rights of the Child. And then there are gender-specific conventions, for instance, the elimination of all forms of discrimination against women. And even though the title of CEDAW, which is its abbreviation, refers to women, it covers women and girls. And I threw in another one there, the UNESCO Convention Against Discrimination in Education. And Sienna had pointed out that there is often economic inequality and issues of girls being given equal access to education. And this convention is there to ensure that, for instance, there is not discrimination against girls when it comes to education. We're going to look at a particular case study that addresses this or applies this convention a bit later. And then we have various regional bodies, as you may know, regional human rights bodies in Africa, in the Americas, Europe, Asia, and the Arab region. And so each of those, just like at the global level, develops their own treaties and laws, charters, regulations, to which member states in that region sign up, adhere. And a number of those that deal with girls' human rights on the African continent, the African Charter on Human and People's Rights, listed the specific articles. I'm not going to go into all of these because of time. Take pictures so you guys, but they're here for reference because oftentimes we think about, we look for specific provisions that mention, girls or, the child, when there are a number of treaties or provisions at global, at regional, and even at national level, domestic laws that can apply, that do not necessarily, that we wouldn't immediately think of. And so on the African continent, as I mentioned, apart from the African Charter on Human and People's Rights, which is the foundational human rights treaty, you have a number of treaties that essentially stem from that, including the African Charter on the Rights and Welfare of the Child, the protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa and the African Youth Charter. I just want to point out that the protocol to the African Charter on Human and People's Rights on the Rights of Women around prohibition on child marriage. And so it's important that we go beyond the title, of course, but also that when thinking about human rights advocacy, especially when it comes to strategic litigation, that you are to go to find legal provisions that are as directly on point and contain explicit prohibitions as possible. In Europe, there are also quite a number of that form or charters that form the legal framework for girls' human rights. Of course, the foundational treaty, the European Convention for the Protection of Human Rights and Fundamental Freedoms. And then there are also a number of optional protocols that are enacted to supplement the foundation. And the treaties. So as you'll see, in Europe, there also has been a recommendation on gender mainstreaming in education. So that's important because regional bodies are able to sort of take that a step further and give specific recommendations to states on how to
I think we've lost you.
I can hear you.
Okay, now we can hear you. Yeah.
Okay. All right. I apologize. It's raining heavily here. So I'm in Sierra Leone. That's where I'm based. I'm in Freetown, Sierra Leone. And this is the rainy season. It's the heavy rainy season. So that does sometimes affect internet connection. So I'm apologizing in advance. But if you are not able to hear me at any point, just drop a note in the chat. All right. So in the meantime, okay, so yes, these recommendations by regional bodies are equally important because they're oftentimes more specific and can get to specific issues that states within that region are either struggling with or they are failing to implement. And so it's really helpful when you have specific recommendations like this one on gender mainstreaming in education from 2007. In the Americas, Asia, and Arab regions, again, apart from protocols to the main convention, you also may have subject matter specific treaties like the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women, which is known as the Convention of Belém do Pará. And again, the fact that it's subject matter specific allows for states to undertake really concrete obligation to eradicate a specific harm against girls or women. As we may know, I'm not sure what you've heard in your other sessions, but some regions have much more developed treaty regimes or legal frameworks than others. So the African, Americas, and European human rights systems have quite a number of treaties, charters, legal frameworks, whereas the Asian region or ASEAN region has a declaration and has not gone as far in developing binding legal frameworks. All right, so as I mentioned, you don't you also, whether domestically or looking at laws domestically or looking at treaties internationally, want to look at anything that can affect an issue, any of the issues that you all have mentioned and raised. So for instance, any laws relating to marriage could or would not have a provision relating to child marriage. Laws relating to domestic violence may have specific provisions relating to violence against children in a domestic setting or domestic violence perpetrated by someone in a position of trust vis-a-vis a child, a girl child. Sexual offenses laws, oftentimes, especially because sexual violence on girls is oftentimes basically a statutory offense that a child cannot consent to sex, and so oftentimes sexual offenses laws will have a provision on rape and then a separate provision specific to sexual violence against a child, and sometimes specifically a girl child, but oftentimes a child, because as sexual violence can be perpetrated against anyone of any gender. Education, we've already mentioned. Offenses against the person, that's usually laws that deal with bodily harm, and then also laws relating to human trafficking. This list is obviously not exhaustive, but it is an opportunity to think about what other legal frameworks or laws relating to other subject matter could be applicable. Okay, so now we're going to move more into some of the practical side of thinking about advocacy for girls' human rights. And as I mentioned at the outset, we're starting by talking generally about advocacy, because as you'll see, legal advocacy is really just one form of basically trying to bring about a certain change. So what is advocacy? It's an organized attempt to influence law, policy, practice, or attitudes. And usually one presents, arguments that are based on evidence and credible evidence. and makes recommendations or puts forward specific asks about how that change should occur. And it's also important to realize that advocacy is not the end result. It's not the change that has been brought about, but it is the process or the action or step of influencing change. Oftentimes we talk about advocacy as like the end result and act in and of itself, but it is a process. So there are a few types of advocacy. Obviously, we're not going to go into all of these. We're going to focus on one, but I did want to highlight that there are various types of advocacy, because I'm going to take you through steps for effective advocacy that apply to all of these different types of advocacy. We're just going to apply it to legal advocacy, i.e. strategic litigation in this case. But policy advocacy is an basically attempt to influence policy or laws, or those who are making decisions on policies or laws, usually at the domestic with or policy making at that level. Public advocacy or campaigns is a little different in that the target of policy advocacy are, it's policymakers, et cetera. Again, usually domestically. The target of public advocacy is really more the broader public. And that's why oftentimes campaigns are fall under this category, because you're trying to essentially put pressure on the public to or build up public pressure for something to change. And this can look like a number of things. It can look like a public, demonstration. It can look like a public petition. It can look like a photo exhibit. It can come in many different forms, but the idea is to really stir up something within the public, to get the public to then put pressure on decision makers. And legal advocacy, which is what we're going to focus on, is essentially when you are utilizing the law, and particularly a legal process, in this case, litigation, to try to bring about a change in law, policy, or practice. So delving more into strategic litigation as a form of legal advocacy, I'd like, well, before I go there, I'd like for you guys to tell me what you know strategic litigation to be. And it also goes by some other names. You may have seen the slide. Impact litigation, public interest litigation. Please use the Q&A box to say what you think strategic litigation is. Thanks, Judith. Using lawsuits to promote or influence social change. That's a good one. Anyone else? So a court case outcome that has the ability to bring about broader social and systemic change beyond the specific case outcome. I like that you're talking about systemic change beyond the specific case outcome. And I also gave you guys a bit of a hint when I referred to strategic litigation by another name as well, impact litigation, which goes to the point that Tilly is making about a broader social and systemic change beyond the specific outcome of the case, or a broader public impact. So the process of bringing a case to court. So what I like about this answer is that you refer to it as a process, right? And it's not just that you don't just refer to the end result. And we're going to talk about that in a second. Yes, class actions are good examples. Well, not all, some class actions are good examples of strategic litigation. Caitlin, I like this. We're going to send a case study about people bringing cases to court, not just for a remedy for themselves, but also to bring about a broader social impact like a policy change. Thank you. Thank you all for those responses. So yeah, exactly. Strategic litigation is a process of not only identifying, but also pursuing specific lawsuits to have a broader social impact or bring about a societal change. And I mean, there are people here from all over the world. Those from the United States will be familiar with strategic litigation and several cases that are commonly associated with strategic litigation. Brown versus Board of Education, Roe v. Wade, and a number of cases that were brought
I think we've lost you, so oh wait, she's rejoining.
heard me say.
Hi, we lost you for a minute. I think you might need to repeat a bit of
Yeah.
what you said before.
Okay, what was the last thing you heard me talking about the US?
Like just before that, so like Brown versus the Board of Education and stuff like that. I think you've broken up again. I don't think we can hear you. There we go. Yeah.
Apologies, guys. Issue the rainy season in their Can you hear me now?
Yeah.
Okay, I'm gonna put the video off. Maybe that'll help with bandwidth. Okay, but you can see the presentation?
Yeah.
Okay, all right. So I was just referring to the context in which people may strategic litigation. In the US, it's often associated with a number of key civil rights cases like Brown versus Board of Education, Roe v. Wade, and other cases that address discrimination or civil rights issues. For those of us outside of the US, we often hear about strategic litigation
We've lost you again.
national criminal proceedings. And that's because, I mean, usually the state is responsible for carrying out prosecutions at the said, there are in some jurisdictions you can have private prosecution, right? And in that case, strategic litigation is an option, and I will be talking about a case study that in which we did that. All right. All right. So there are 7 steps to effective legal advocacy. I'm going to really run through these pretty quickly, but again, this is to really practicalize strategic litigation, and also think about it in a framework that applies to all of your advocacy. So these are the same 7 steps you're going to use if you're doing policy advocacy, or if you're doing or if you're campaigning, for the most part. Yeah, I mean, these are the same steps you're going to use. I'll show you how they apply specifically to litigation. The first step is identifying the issue, and I do go back, and the reason why it is in this shape is because it is a cycle. So keep in mind that once we go through these 7 steps, you essentially go back to step 1. And so I want to say that now in case I forget later, but that's why you see that formation. As you guys do, identifying pressing issues that affect girls' rights now, or that you know of, that are real problems, things that you may be in
Eleanor, it's broken up again. So you might have to repeat what you said just now. It says you're speaking, but we can't hear you.
I'm going to try to also connect to an alternative.
Yeah, Eleanor, would it be maybe possible we go into the exercise?
Okay.
And then maybe we continue with the rest?
And then come back. Yeah.
Yeah.
Okay. Well, I'd love to, Ivana.
Mhm.
I'd love to go through the steps as it may help with the exercise,
Mhm.
and then we go to that point.
Okay, perfect.
Or shall we continue? Or do you want to continue? I
No,
can
no,
actually
no.
see you on my screen, so I'm not sure whether if you're nodding or.
No, sorry. Basically, yeah. You can definitely try. I'm also thinking we can try again. I can hear you very well right now. So, and maybe what we can do, I can share the presentation from my side because maybe that's also interfering with your bandwidth and internet connection. So can you send the presentation to me quickly and I can share it from my side? Yeah, so sorry everyone for this technical issue that we're having with Eleanor. I'm very, very sorry. I'll share on the Mighty Network the exercise that we have.
Yeah, please go
I
ahead
might
with the
also try
exercise.
to upload also the.
Please go ahead with the exercise. Oh, we figured this out.
Okay, we'll meet in a minute. Okay, so the exercise, I'm gonna post this on. I'll post this at the Mighty Network. Okay, so to everyone, I will also share my screen, and as we did it the last time, so the exercise is posted in the Mighty Network. So your assignment is to do a landmark case, a short summary on a landmark case that impacted girls' human rights. You need to choose the landmark case, check in Google in everything that you find, and you have to read the case, and then do a summary of the case. Please check 2-3 sources, and then you do like a short summary of 150 words to 50 words, and then you have to put it here. It'll be very good, and then I'll say we'll meet again in 11:30, and we'll go through each of the cases with Eleanor. How does it sound? Let me see if there is any questions. Yes, we definitely will go through the steps. Try to do the summary, and then we'll also see what potentially could have been done different things by you. And we can basically, maybe in 30 minutes, you would have the time to do the summary. We go and finalize Eleanor's presentation, and then we go and review the submission. Is that fine? We might meet at 11:25. Please put it on. See you at 11:25.
Ilvana, I don't think we can hear you talk.
I hear you. What did you say?
Sorry, I think before I couldn't hear you, but now I can.
Okay. Yeah. So everyone, sorry, I thought so. So basically we have started, and I was telling Eleanor on how we did it the last few sessions, that we have given the chance to everyone to read out loud their responses and their submissions. So I see already that we have a couple. So please, whoever wants to start first, either raise your hand or type it on the chat box, so we can start. And since we have Eleanor here, she will basically tell you and give you the feedback immediately on how your case summary is done. So we have an expert at hand, so that will be a good chance. And I already have Maria. Eleanor, is everything good on your end? Can you hear us?
I can hear you.
Perfect. Okay. Let me then give it to Maria.
Hello, can you hear me?
Yeah.
Okay. Hello, Eleanor, as well. Thank you for your session. So my case is the case from Legal and Human Rights Center and Center for Reproductive Rights, Tanzania. And basically, this was a case brought in 2022 by this center. And it was brought against it was brought in the African Committee of Experts on the Rights and Welfare of the Child against Tanzania, and it was on behalf of 6 Tanzanian schoolgirls who were expelled for being pregnant. And the complaint challenged the standing policy of mandatory pregnancy testing, expulsion of pregnant girls and married girls, a lack of access of reproductive health services. The African Committee on Experts on the Rights and Welfare of the Child held that Tanzania had violated several rights under the African Charter on the Rights and Welfare of the Child, including non-discrimination, education, health, protection from abuse, and the best interest of the child. And it recommended Tanzania to end these practices, including mandatory pregnancy testing, to readmit expelled girls, and to ensure access to sexual and reproductive health education and services. And the significance is that it was the first time a regional human rights body held a country accountable for education-based discrimination against pregnant girls. And then you can see the 3 sources below.
Thank you so much. I think that was a great summary and addressed one of the issues. One of the case studies actually that I was going to cover. That's not the case in Tanzania, but a case in Sierra Leone. And I think one thing that's important about strategic litigation is that oftentimes the strategic aspect is about building up, slowly bringing a case that tests one aspect of an issue, and then maybe the next step is bringing another case that tests another aspect of the issue. So for instance, in Sierra Leone, a case was brought by Women Against Violence and Exploitation in Society, called WAVES, Equality Now and IHRDA, to challenge a ban that the government of Sierra Leone, a policy that the government of Sierra Leone had that barred pregnant schoolgirls from attending mainstream school. So in the same way that Tanzania had that ban. And the ECOWAS court ruled in 2019 that the ban had to be revoked and Sierra Leone should take steps to abolish alternative schools for pregnant girls. The Tanzania case that you just summarized and did a great job of summarizing addresses the issue of the pregnancy tests. So as you can see, it's another aspect of an issue that contributes to the whole violation of lack of access to quality education for pregnant schoolgirls. And so while Tanzania did revoke the ban in 2021, as the African Committee of Experts pointed out, that circular revoking the ban doesn't address this issue of the requirement to take pregnancy tests. So thank you. That was a great example.
Thank you. Thank you for your comments as well.
Who do we have next? Tilly, oh, Flora, you have, I'm gonna allow you to talk. Perfect, thank you.
Hello?
Yeah.
Oh, okay. So the case that I chose was the KL versus Peru, decided in 2005 by the UN Human Rights Committee. Basically, KL was a 17-year-old girl living in Peru, and during her pregnancy, the doctors discovered that the fetus had a condition called anencephaly, which is basically a fatal birth defect where parts of the brain and the skull are missing. And this meant that obviously the baby wouldn't survive after birth. And under Peruvian law, the therapeutic abortion was allowed when the mother's health was at risk, but despite this, the hospital refused to perform the abortion, and the doctors were afraid of legal consequences, even though the law technically supported KL's right to choose. So as a result, she was forced to carry the pregnancy to term, only to watch the baby die shortly after birth. And this caused deep emotional trauma and obviously long-term psychological harm. So she brought her case to the UN Human Rights Committee, arguing that her rights had been violated, including her right to be free from cruel, inhuman treatment and her right to privacy and special protection as a minor. So in 2005, the committee ruled in her favour, stating that Peru had violated her human rights. And this was a big historic decision because it was the first time that an international body had held a government accountable for denying a legal abortion in the case of a fetal a fatal fetal condition. So I chose this case because it's quite important for girls around the world, as it shows that access to reproductive health care is not just a medical condition, a medical issue, but it's a human rights issue. And it shows that the importance of making sure national laws are actually applied in practice is important, especially for young girls in vulnerable situations. And I didn't put the sources down, but the sources I used were the case documents from the UN Human Rights Committee and the Kale versus Peru historic decision on abortion rights from the Center of Reproductive Rights, and then some reports on reproductive justice in Latin America by Amnesty International.
Thanks, Flora. Really quickly, I'm gonna just comment and say thanks. I mean, good, another great summary, and also highlighting what it was important about the case. One thing I want to point out is the choice of forum, the choice of human rights bodies. So this was a situation that happened in Peru, but they chose to go to the UN Human Rights Committee, right? And so when we're talking about strategic litigation, one of the things that was going to go through in terms of the steps for effective advocacy is thinking about what's your target and thinking about the most appropriate forum, right, for bringing the litigation. And in this case, it was effective going to the UN Human Rights Committee as opposed to perhaps going to the Inter-American Commission or court. Thank you.
Thank you.
Thank you, Flora. So do we have another one? And Eleanor, I know that we have a lot of submissions, but how do you think if no one else wants to speak, and maybe we can continue with the rest of the presentation, and maybe in like the last 5 minutes we can check and go through any of those that you might find interesting.
So, I mean, I'd love, I mean, especially since they took the time to do their case summaries, that we can focus on that. I've shared the presentation. So the only thing I'd love to talk through at least one, or I've already spoken about one of the case studies I was going to present. I'd love to talk about the most recent one, and I can do that at the end, but I'd love to hear more of
Okay,
the
perfect.
summary.
Yeah, it's completely up to you. Please raise your hands, and I have Tilly right now. Tilly, let me just find your
Can you hear me?
submission. Okay, I have here Manuela Liz El
Can
Salvador.
you hear me?
Yeah.
I'm not sure if my audio is working.
We can hear you.
Oh, you can hear me.
Yeah. It's a
so
bit,
while
it's a bit,
Is it better now?
it's a bit low, but
A bit low. Is that better now?
Yeah.
Okay. So while this case isn't specifically about a girl, it's about a woman. The court references a lot about education and girls in their documents, which I thought was interesting. So this is Manuela versus El Salvador in 2021, and essentially in 2008 she was a mother of two from a rural area, low income. She suffered a miscarriage and sought medical care, but instead she was interrogated, reported, detained without due process and sentenced to 30 years in prison, based on the presumption that she had terminated her pregnancy, and it wasn't a miscarriage. So her rights to health were denied in custody, and she later died in prison as a result. And this was taken to the Inter-American Court and found that El Salvador had violated multiple rights to personal liberty, health, privacy, due process, but also harmed the rights of her family as she had 2 young children. It criticizes gender stereotypes, breach of confidentiality, essentially saying that the state had failed to protect, respect, and fulfill human rights obligations. So in the court commentary of the case, there's some quotes that I've put here, and it says the importance of informing women at the local level, organising information campaigns and advisory committees. So it's recognising the barrier to rights that is a lack of information, and highlights the state's responsibility, especially in rural and marginalised areas, which is quite a focus of the Inter-American Court actually in other cases. But it also mentions, which is the part that links to girls specifically rather than women, is about the school curriculum and age-appropriate information that takes into account the evolving capacities of children and adolescents, which highlights the importance on educating girls of their rights and protecting them from a young age in order to prevent similar cases as they develop and into their adulthood. It recognises bodily autonomy, importance of consent, and making sure that girls from a young age understand their legal protections. As it says, education as a tool for empowerment, moving away from simply academic education. It sort of reflects an alignment of the court with international standards under the CRC, Convention on the Rights of the Child, which recognises the ability of children to make decisions grows as they grow, and supports the idea that girls should be trusted with more knowledge and autonomy about their bodies, which could prevent similar tragic cases as that happened to Manuela. However, it doesn't go as far as recognising abortion as a right. It only deals with the criminalisation process of women who seek abortions because of emergency, which can be extended to girls. And I think this reflects sort of the court is treading quite carefully. It recognises the sensitivity of the issue within the population in El Salvador. While not explicitly saying there's a right to be able to terminate pregnancies, it relies on potentially more grassroots state activism and things to evolve this right, but it definitely puts in the foundations for the development of the right to abortion and a need for sort of structural change within government and institutions to make long-term changes to how they support and educate girls from a young age. So, yeah.
Thanks, Tilly. So picking up where you left off, if you are approached by maybe not the same plaintiff or applicant, but someone else, a girl who was in the same circumstances as the woman in this case, right? And wanted to terminate her pregnancy. If you were in that position, in the position of being approached to be her lawyer, what could you do in terms of strategic litigation, or what would your next step be in terms of bringing a case on this issue? What would you focus on, or like what violation, or what would you focus on? What approach would you try to take?
You probably focus on the right of a child to be a child, and set out in the CRC, and the right to health is an important one because of what this woman suffered, and the right for a full and sort of comprehensive education, and bodily autonomy. This case could be extended to its relevance to girls, and the court does touch on that. Yeah.
Okay, so you would try to pick up on those points and use that now as a launch pad for additional litigation that gives you a more concrete decision on the right of the child, some of the rights of the child, of the girl child. Okay. All right, great.
Thank you so much. Tilly, I have here Sri Lakshmi.
Hello, can you hear me?
Yeah, and then followed by Christy. Christy, I also allow you so you can be ready. Yeah, Sri Lakshmi. Fine. Thank you to everyone who has made the submission. They're very interesting to read through them. I have it here.
Great, thank you. And thank you also, Eleanor, for the presentation. It was really interesting. So the case that I chose to look at was called Opus versus Turkey. I realized I didn't put the date here. It was the official ruling was made on June the 9th, 2009. So this case was really a landmark case for not just girls' rights, but women's human rights as well, in terms of how states relate to the private sphere of domestic violence and whether they should intervene or not. So to go into a bit of background, what happened was that Mrs. Opus, she was a Turkish woman. She suffered quite grievous domestic violence at the hands of her husband and also her ex-husband. So that were things like attempted murder, death threats, physical assault, and then ultimately her mother was shot and killed by her ex-partner. So there were a lot of quite serious incidents in the background to this case. So when she tried to raise it with local authorities, as you can see, she did bring it to state authorities on multiple occasions, but then she discontinued with the complaints, mostly because of, and this is in the sources that I've listed at the bottom, mostly because of cultural pressure and societal pressure. So there was very much a sense of Turkey's, at the time, sort of atmosphere contributing to that pressure. But then later on, she decided to bring a complaint to the European Court of Human Rights, alleging all of the things that happened. So all the violence, death threats, harassment. And so the court's ruling actually was that the Turkish government violated Articles 2, 3, and 14 of the ECHR, which off the top of my head are the right to life, right to freedom from torture, and then the right to not be discriminated against in terms of gender. So the court found all of these things to be true. And what was really interesting about it is that they didn't need it to be a purposeful violation. They didn't need the Turkish government to have looked the other way to call it a violation. Just a simple lack of action. The presence of the presence of statehood inaction was enough to secure a conviction on that term. So that's what really makes it a landmark case, because it enshrines and it inextricably connects the right for women to be safe from domestic violence to the responsibility of states to keep their inhabitants safe. So it built quite heavily on a precedent set by a case that was carried forward in Slovenia, I believe, a few years prior. But what was really interesting about it is, again, that thing of countries don't actually have to do something bad, they can just not do something good, and that is enough to secure a conviction. So it basically enshrines the right of women to be protected, because a lack of protection on the grounds of it being domestic violence is enough to constitute gender discrimination. So that's why this case was so important, and it provides an impetus for states to act. So the sources I used, I've listed at the bottom. Thank you.
Thanks, Sri Lakshmi. A great summary, as well as explaining what the linkage is with the rights of girls, so the rights of inhabitants in the house. Also, highlighting the importance of human rights courts finding that the state doesn't have to be the direct perpetrator. So it's not just about acts that constitute violations of human rights, but also omissions. And actually the case study I'll tell you about on FGM, the ECOWAS court found similarly that the state is complicit by not banning certain conduct, or by not doing what is within the state's power. It becomes complicit in human rights violations carried out by private actors. So, thanks. Really important.
Thanks.
Thank you so much, Shilakshmi. And I think we have Chrissy, and afterwards, I think we might go to the case. We're looking forward to hear how you dealt with it, Eleanor. Such an amazing achievement and contributions, like quite landmark indeed. Christy, the floor is yours. Let me find, please, your submission here. Here. Perfect. Here?
Okay. Yeah. Can you guys hear me?
Yeah.
Okay, so the case that I chose was Dobbs versus Jackson Women's Health Organization. And I chose, by the way, I'm from the United States. I feel like that's like an important thing to add. But the reason why I chose that case specifically, because it kind of set a precedent for the rollback of human rights in the United States, which is something we're currently going through right now under Trump's administration. So essentially what this case is that it was brought forth by Jackson Women's Health Organization, which was the only abortion clinic in Mississippi. And for the people that are not from the United States, Mississippi is one of our 50 states. So yeah, that's important to know. But yeah, back to the case. So the case challenged a Mississippi law that was set that banned most abortions after 15 weeks of pregnancy, even in cases of rape or incest. And this directly conflicted with Roe versus Wade, which was a case from 1973 that basically protected the right to abortion until 24 weeks. And the outcome of this Dobbs versus the Women's Health Organization is that the Supreme Court in 2022 ruled in favor of Mississippi, overturning Roe versus Wade, which was insane. But this meant that there was no longer a federal constitutional right to abortion, and that each state can now make its laws about abortion, including banning it completely. And that's the kind of thing with conservatives. They're really big on letting the states decide whatever to do with their own states. So that's important to know as well. And why was this case important for girls' rights? Well, essentially, it stripped away the national protection that allowed women and, well, girls to make decisions about their own bodies. And after this case was ruled, basically what happened is that in many states in the South of the United States and in the Midwest, abortion access was completely banned or severely restricted, even in cases of rape or involving a minor. And I mean, wow. But one thing also to note is that, yeah, that in a lot of states, it also became criminalized to travel across state lines, which meant that you couldn't like get up and get an abortion elsewhere in another state because you could go to jail. So that happened in Texas. And yeah, basically Dobbs versus Jackson overruled Roe versus Wade, ending the federal right to abortion and putting millions of girls and women at risk of losing control over their reproductive health. Thank you.
Thanks so much, Christy. I'm going to appreciate you because you brought in an example of where strategic litigation had an effect on rolling back girls' rights. And I wanted to do that today for us to talk about at least one case. So thank you for doing that. Strategic litigation, first of all, does not have a guaranteed outcome, right? So you can win or lose a case, but whatever the judgment is really becomes a legal precedent, and that precedent could advance girls' rights or it can roll back girls' rights, as in this case. Also, it's important to know that strategic litigation isn't only used by like civil rights lawyers or human rights lawyers or like activists, people who are trying to, further protect rights. Strategic litigation is also used by those who want to do the opposite, right? Because they want to get this kind of a judgment that sets a precedent, and it's hard to overturn precedent. So it's and it takes time. And so thank you for bringing this up and showing us sort of the flip side of strategic litigation. It's also something to consider when you're going through the steps about whether to decide to pursue strategic litigation. There are risks, weighing the risks, and then also like how likely what type of court are you going before? Is it one that is likely to that tends to lean a certain way? Those are all important considerations. And then, what resources do you have? Strategic litigation takes time, and there is no set time frame. I know that one of the steps I put in the presentation is about setting your timeline, but with strategic litigation, there's a lot of uncertainty as to timeframes, because you only can go as fast as the court or as fast as whatever process is happening. There's a lot of money being pumped into this type of litigation now by groups in the US, conservative groups that are trying to roll back many of what others considered advancements in human rights or civil rights protections. And those deep pockets, activists on the other side may not have as deep pockets. So these are all important considerations. Thanks so much, Christy.
Yeah.
Thank you very much, Christy. Okay, Eleanor, do you want me to share the slides or?
I'll go quick because I know that time has really gone.
Yeah.
Oops. I don't actually need to share my screen.
Perfect.
Oh, well, I mean, I could just talk about it, but since I'm here, I might as well. Okay. So, all right. So, the matter that I want to discuss, I don't know if it's come up for you yet. My computer's a little, okay, there we go.
Yeah.
Continue to share. Okay, I'm getting some strange, anyway, let me just talk about the case. So, this matter really was the culmination of a long process that started in 2020 or 2021 or so, where the lady who you see in this photo from The Guardian piece, Khadija, who's a survivor of FGM, she she came back into Sierra Leone after having fled after she in 2016 she was forcefully subjected to FGM as an adult. She's an adult, forcefully subjected to FGM, and she had to flee the country because those who perpetrated it even surrounded the hospital where she was getting treatment and basically tried to hurt her. And when she came back into the country, she contacted a lawyer colleague, and then that's when discussions, some of us were brought in, discussions started about what can be done. And we didn't go straight to litigation. And that's why I wanted to go through with you the steps, because this is a sensitive issue in Sierra Leone. Female genital mutilation is conflated with a cultural practice called bondo, which is it's a cultural ceremony. It's like a rite of passage. But unfortunately, FGM has been incorporated into this. That's not necessarily what the culture ultimately originally was, but it's made it a sensitive issue in Sierra Leone. So I was tasked with coming up with a strategy on how to basically get what we wanted at the end of the day, which was to try to eradicate FGM in Sierra Leone in law and in practice. And I proposed a three-pronged strategy. There was already a bill in Parliament, a Child Rights Amendment Act, or a new child rights bill in Parliament that could include, the proposed bill included an explicit prohibition on FGM, and that would apply to children. But also, and so obviously doing some legislative advocacy to push it forward. But then also, I proposed a two-pronged strategic litigation approach. One is to go to the ECOWAS court, bring a case to the ECOWAS court with Khadija as one of the applicants, and then 2 NGOs as public interest plaintiffs. And as you'll see, the name of the case is Forum Against Harmful Practices and 2 others. And that's because it was a strategic decision to not have Khadija's name be the first name out of protection for her. And have the case named after the Forum Against Harmful Practices, who for decades has been working to try to end FGM in Sierra Leone. And then the other simultaneous strategic litigation approach was to bring a private prosecution in domestic court. Remember, I said earlier that it's really rare to see strategic litigation in terms of like domestic criminal matters. Except where you have the ability to bring a private prosecution. The state had made no effort to investigate or prosecute the perpetrator of the crimes and the violations of Khadija. And so myself and a small team, we decided we were going to pursue a private prosecution. So we did those simultaneously. We filed those cases simultaneously in domestic court and the ECOWAS court. And at the ECOWAS court, a month ago, almost a month ago exactly, actually, we got a judgment that the state of Sierra Leone was held responsible for violating the Maputo Protocol and the African Charter on the Rights and Welfare of the Child. You recall earlier I mentioned that those treaties specifically refer to FGM as harmful practices and violence, as constituting violence against women, and that member states of the African Union who ratified these treaties, these human rights treaties, should explicitly prohibit or criminalize FGM, both for women, adult women, and for girls. And FGM is most prevalent in Sierra Leone amongst girls. There's I think 80 to 90%, 80%, 80+% rate of FGM in Sierra Leone. And so yes, we were successful in being able to not only get the court to rule that there were violations of those treaties, but also that there were specific violations of Khadija's rights to security of her person, to access justice because the perpetrators had not been brought to book, and also to be free from inhuman and degrading treatment. But what's even more compelling about this case is the language that the court used in its decision. As I mentioned earlier, this is a sensitive issue, not just in Sierra Leone, but in many countries in West Africa. And the ECOWAS court, sorry, is the regional court for West Africa and has the power to hear human rights cases. The court went so far as to state and declare that FGM is one of the worst forms of violence against women. Certainly, I wasn't expecting the court to go that far in its language, but it did. And that now sets up an important precedent for other courts, not just domestically in West Africa or on the African continent, but beyond where this where FGM is practiced. And the court also ordered that the state should investigate and prosecute, that it's not the responsibility of the victim to bring her own prosecution in domestic court. And so the state needs to do that. And so in a way, that also helps push forward the domestic case. And so the fact that we brought those cases simultaneously, which I had recommended at the outset, actually helped. It helped not just with the ECOWAS court ruling, but it also helps now actually bring the perpetrator to book, because the ECOWAS court has made a declaration on that and made orders on that. Yeah, this is the most recent case that I've been involved in that affects girls' rights, and we really Khadija really has been incredibly courageous in the fact that she brought this case, but she's always said from the start that she did it not just for herself, but for the girls and women of Sierra Leone. And also, the last thing I want to leave you with is the importance of strategic litigation, not only for setting legal precedents, but also for maybe advancing advocacy, policy advocacy, legislative advocacy, even in other countries. So we saw it in the pregnant schoolgirls case. The ECOWAS court's decision helped push Tanzania to also remove its ban, even though there still needed to be litigation about the pregnancy test requirement. But in this case, we saw last year the Gambia, it's another country in West Africa, the legislature attempted to repeal longstanding legislation that banned FGM in the country. And the pushback, the advocacy of a number of girls' rights advocates was really bolstered. I mean, obviously this FGM judgment on Sierra Leone hadn't come out yet, but was really bolstered by just the fact that that case was before the court, and and now any advocacy that's being done by activists, girls' rights advocates or activists in the region can rely on the ECOWAS court case. It doesn't mean they have to go to court, but they can use that to say, well, all West African states who are part of ECOWAS, this is your obligation. So that's where we are. A few days before the ECOWAS court rendered this decision, literally a few days, our parliament unfortunately decided to pass the child rights bill that I mentioned without an explicit ban on FGM. And so currently our advocacy is that the president, who the bill is before for his assent, needs to not assent to the bill, especially given that he is currently the chair of ECOWAS, of the ECOWAS heads of state. And that would look really, really poor on his part to basically defy the court of the body that he is currently heading, and to send it back to Parliament. And so it's also important when you're thinking about strategic litigation to think about opportune moments. So we didn't know that, you know, the president of Sierra Leone was going to become the chair of ECOWAS, but the timing of this judgment coinciding with his chairmanship now presents us an opportunity to use the judgment for advocacy. So I'll stop there and yeah, leave you with that. Hello? Hello?
Hi.
Okay, yeah.
Don't worry, we can hear you and everything.
Okay. Yep. So that's it from my end. It's been a pleasure to interact with you guys. Sorry for the technical difficulties. This is what we have to deal with.
No, it
On
was
a regular
amazing.
basis. On a regular basis. But it was great to hear your summaries. I think you all are doing a great job of advocacy, of understanding, you know, the law surrounding girls' rights. And I wish everyone the best. My contact information is on the last slide. I don't know if you can't still see my screen.
Yeah. I also
You can?
shared them with everyone on the
Perfect.
Mental Network. Thank you so much,
Perfect.
Eleanor. It was so great. We're so grateful for sharing and for having, well, also this opportunity to hear from the one herself that delivered the case against FGM. It's a breakthrough, and again, as I said, we were very happy and lucky to have you here with us. I hope everyone enjoy this session. The technical difficulties happen all the time in the in doing webinars, but thank you so much, Eleanor. I hope everyone enjoyed it. And again, we have the cases. Please do check on each other's summaries that you've done, and we'll see you again tomorrow at the same time for the last session of the Gross Human Rights Virtual Work Experience Program. Thank you, Eleanor. Thank you, Safi.
Thank you, everyone. It's been a pleasure. Bye.